Hi, I'm Karen Salmon. I'm one of the partners here at Marlborough Law, and this is our fourth podcast. On to my left, that is my left. To your right, we have Alex, who is the other partner in the business.
Increasingly worried partner.
And on my right, I have Daniel, who's just joined the firm to bring mediation to the company. Now, those of you who know Marlborough Law and have listened to some of our previous podcasts will know that we are a non-confrontational firm, and we pride ourselves on that. We try and work with clients to make sure that they get the best result from their case with the least amount of stress and anxiety. And a lot of clients come to us and say, all right, we just want to go to court. Just put the application in, let's get to court. And I've said before, court is a very arduous process. It can be very emotional. It can take months and months. So what we recommend in the first instance is mediation. And Daniel's going to explain a little bit about what mediation is and why, as a firm, we think it's really important. Aren't you, Daniel?
Yes, thank you, Karen. So I'm a registered mediator with what we call a Civil Mediation Council. I'll refer to it as a CMC, just for the benefit of the listeners here today. And at its core, it's a regulated body and recognised both in the UK and overseas, and promotes mediation as a method of resolving disputes outside of the courtrooms. And as Karen rightly says, the issue with the courtrooms is it can be very time-consuming, very costly, and stressful for the parties involved.
Yes, because they're sometimes in the same area, aren't they? Especially at some of the courts that we go to, there's very little areas, so you're bound to bump into the person you're on the other side.
Absolutely. Yeah. And strangely enough, that's one of the overarching issues that I get addressed with normally, is the fact that one of the questions I get, will I get to see the other side? Will the other side be there? Yeah. And we're trained in such a way that the parties, both in-house and virtually, which I'll discuss in a minute, they don't meet each other. Okay. So how we set up the system, just to give the confidence to the listeners, is that we have two rooms. Mm-hmm. Each will be dedicated their room for, we typically sort of say around 3 to 4 hours to a day, okay, where we can complete the mediation successfully. And neither party would need to meet. So it's very controlled manner. And that's one of the overarching questions that I get asked, actually, before cost or anything else. Right. Is, will I get to see the other party? Naturally, it's a conflicting situation.
Yeah, especially in family or...
Yeah, family, civil, commercial. We tend to, neighbouring disputes is one of the highest areas. And naturally, you do tend to find that if you have a neighbouring dispute, the parties are living nearby or next door to each other. Yeah. And of course, if you have court proceedings and they're drawn out, that dispute can get worse and cause other issues. Yeah. Mediation actually eliminates that, and we do facilitate our diaries to ensure mediation happens for the parties to minimise the risk of dispute worsening. Okay. And generally speaking, after the first inquiries, we can normally facilitate it within a week or 2 weeks, and both parties are encouraged.
Yeah, but you're not there to tell people what to do, are you? I mean, a lot of people have said to us, "Oh, will he make a decision for us?" Well, no, you don't make a decision, do you?
No,
that's for a judge to do.
Absolutely, and I'm gled you raised that. That was one of the points, and one of the benefits of mediation is the parties will make their own judgment. Okay, the judgment isn't imposed on them. And sometimes when you go through the court proceedings and a judgment is imposed, notwithstanding the cost that involved afterwards, one party can still feel grieved, right, despite going through the process. Whereas if you've got mediation, the parties will make their own judgment. They will make their own settlement. And I know at Marlborough Law, once an agreement has been agreed between the parties, normally typically within the day, a settlement agreement can be done.
Yeah, it's all written up, yeah.
It's written up, it's binding on the parties. And generally speaking, the parties, in my experiences, have shaken hands at the end of the day. Yeah. Completely the opposite to what they arrived into.
No.
Yeah.
In court, we just run.
Yes, absolutely.
No, totally. I totally agree. I think it's almost the art of compromise and trying to find that compromise. And the one I've always told my clients generally is a good mediation is where everyone walks away not totally happy, but content.
Absolutely, Alex. And you're absolutely right in the fact that when they feel like they've had the deciding decision, one and both parties, it generally is a lot easier. It's more palatable. I quickly mentioned about cost in the courtrooms, and naturally, not always, but naturally, the losing party would normally pay the cost of the winning party, and that can have ongoing effects. You know, you talk about neighbouring dispute. You've come out of a courtroom, you've not satisfied with the outcome that the judge has made, and you've had no input. One of the lines I normally get to hear is from the judgment is that they lied about this or they lied about that. Really, really awkward and that's the difficult part about it. With mediation, it's done on a without prejudice basis.
Yeah.
So the parties can talk openly to the mediator, and that's confidential. And that's not shared with the other party.
No.
The mediators are trained, certainly that with the CMC, to be able to mediate and draw out what is needed, the main points of the dispute. And that's where the settlement comes from.
I mean, that's definitely a plus, isn't it? Because I don't know about you, Alex, but I've definitely been in court where I thought I was on a winning streak, and then all of a sudden, you know, the clients come up with something, or the other side's come up with something that we knew nothing about, and you're just, okay, where do we go from here now?
Totally, it's an ongoing litigation experience where you realise your client, not necessarily lying, but has either been economical or not realised that certain pertinent points are actually so material to their case, and no matter how many client meetings you have and sit down and go through everything, it's amazing what can be missed. And mediation has a way of drawing that out, but in an environment which is actually healthy for your client, as opposed to, oh my God, you're looking at your barrister's looking at you, you're sweating horribly because you know your client, maybe 2 years into your case, has told you something which, that's it. But they've just materially sort of missed out for one component, which is going to make them win or lose.
You had that recently, didn't you, in a civil case? Was it about a lease or something like that?
Yes. Well, let's not talk about that. But, it's surprising what happens. Sort of clarity with whoever's advising you is absolutely vital. But no, going back to Daniel and mediation, any form of alternative dispute resolution is really being pushed by the courts for the last few years. It's such an important way of viewing of a legal system now, certainly in a way which when I started wasn't approached. And to be perfectly honest, if you haven't considered it and you take your claim on, there are question marks to be had about how you're going to proceed with your claim.
Absolutely. And another good point that you've raised there is some parties may appear in the courtrooms had it not attended mediation or at least attempted it, and the judge is quite rightly able to send them away for mediation. Okay. It certainly is a more, and also if you were to go to a cost hearing following, it may be deemed unacceptable and cost may vary somewhat if you haven't at least attempted mediation. It certainly is at the forefront of the courts now. The courts are bursting at the seams. My experience of mediation was somewhat blinkered before I started to train him, but actually opening my eyes to it and the satisfaction, I guess, as a mediator, seeing the parties walking away happy with no more conflict is really, really great. I think it's the way to go, certainly in the interim period. So
I'm really excited about it. I mean, as I say, we're not a confrontational firm. And I think we've definitely got some cases in Hungerford that could do with mediation. It's almost the nice way to go, isn't it?
Yeah.
And like you say, judges do want to see that you've at least tried to negotiate before you get into court. So, yeah, I'm looking forward to doing a bit more of that. Or at least watching Daniel in action.
Yeah, absolutely. Yeah, by all means. But yeah, no, it's and we do it virtually as well with the abuse passion of the internet and Zoom. And again, that is the same format as it was before.
Brilliant.
So thank you very much for tuning in.
Yeah.
And remember, when it comes to resolving conflicts, mediation may just be the key to unlocking a brighter future. Till next time, stay open-minded, stay resolved, stay tuned for more insight and power of the mediation.
Thank you very much.